Well, a deed of trust sale is when we're talking about, we're going to be talking to the context of personal residences again. We're back to that.
Yeah, let's go back to, because most of the people here,
Right.
our viewers, are going to be dealing with their residences.
Right.
And so folks, investment properties may go a little beyond what we're talking about here.
Right. So most of those are going to be secured by a deed of trust.
Yes.
The mortgages are going to be secured by a deed of trust, which means that when it comes time, if the property is going to be foreclosed because of a default on the payment, the lender has a choice of either going to court and doing what's called a judicial foreclosure or going through a trustee sale. Trustee sale is most of the time what's going to be used almost all the time for lots of reasons. But
Here in California, by the way.
Right. But what that means is if it's non-recourse financing, then, as you said before, the property is deemed to have transferred for the amount of the mortgage, regardless if it went for less than that on the market.
Yes.
And so in a trustee sale, the sales price, so to speak, is the amount of the debt, the amount of the non-recourse mortgage. And so there's no income tax consequence to that. There's no debt relief income, and it's treated as from the standpoint of taxation, as non-taxable event because of the non-recourse nature of the debt.
Okay. Now, so that was a deed of trust non-recourse. How about a short sale with a non-recourse debt?
A short sale with a non-recourse debt is a little more complicated simply because it's not a trustee sale. Mm-hmm. So it's not the lender going after the collateral, mm-hmm. And having to be satisfied with the amount of the property, whatever the property's worth, which we know is non-taxable. In a short sale situation, the question is whether or not it's going to be taxable if it sells for less than the amount of the mortgage when it's non-recourse. And there is case law that says that it will be non-taxable as long as part of the transaction is that the debt is forgiven as part, as a condition of the sale. Mm-hmm. In, I would say, just about every case, you would want to make sure that you had an arrangement that said that. Yeah. But if you're doing a short sale, you're basically going to have the lender agree. If it's non-recourse debt, they're going to need to agree that they're not going to pursue a deficiency. Right. So you're probably going to qualify in that situation for a non-taxable event. So
when we say non-taxable, again, we're talking about treated as sale for the amount of the mortgage.
Right,
yes.
in the short sale context as well as the deed of trust.
Yeah.
And I would argue that even if that language wasn't specifically there, that if you look at how the IRS looks at non-recourse financing and it's a situation where the lender cannot pursue a deficiency, even in a short sale, if you have the agreement that they aren't pursuing the deficiency because it's non-recourse, I think you have a good argument that it should be non-taxable.
Yeah, you might want to disclose it. You might want to disclose in any case because we're hanging our hats on this case.
Right.
So it's called the Breyer Park decision.
Yeah, Fifth Circuit decision.
So we're all hoping that this holds up. It seems like the IRS in its literature and so forth is pretty much going along with this concept. So some of these things we're waiting for case law to develop, which we're going to be seeing happen in the coming years as the IRS audits some of the tax returns for people that are dealing with these transactions right now.
Unfortunately, it will take a very long time because the court system is a slow process anyway, and if cases are appealed through the system, it could take years before you get final resolution.
Yeah, that's okay. What's the tax consequence of a foreclosure for a recourse debt?
Okay, again, the most typical transaction in California for residential property is going to be a trustee sale. But this time, because it's recourse financing, the difference between what the property sells for in the trustee sale and the amount of the mortgage is treated as canceled indebtedness. And then you still have the issue of gain or loss. That depends on basis and all that. But for most of these properties, there's not going to be a gain or loss issue. It's going to be an ordinary income issue based on cancellation of indebtedness. And so the tax consequences are going to be that it's a taxable event. Mm-hmm. There may be ways of avoiding the tax consequences, several ways that might happen. But if you can't avoid them, then you're going to have a tax consequence, both state and federal.
Yuck. Okay. And how about a short sale with a recourse debt? I'm going down the litany here, folks.
Yeah, it's essentially the same kind of the same kind of problem. The sales price of the property is going to be the amount you're going to realize on the sale, and so if the mortgage is more than that, then you're going to want to get the lender to agree not to pursue that. If they don't agree not to pursue it and you close the sale, you don't have any income.
Yeah, no cancellation of debt. You just owe all this money.
Nothing's been forgiven, they might sue you.
Darn.
So until they let that lapse or whatever, you don't have to worry about income tax. But if they do agree not to pursue it, or to the extent they agree not to, then you would have a tax issue. Mm-hmm. And again, the next step is to look at, well, what does that mean? What do we do about that?
Okay. All right, so now let's get a little bit into these exclusions. I understand that there's a federal tax exclusion for cancellation debt for a principal residence. Can you explain that a little bit?
Right. So you have to be careful to keep in mind that this applies to certain kinds of properties. We're talking about personal residences,
right,
but we're also talking about somebody's principal residence in this case, because we're talking about a federal law that has its own wording.
Yes.
And so every time you have a law, you have to look at the wording of the law. We're talking about acquisition indebtedness for a principal residence, and within limitations, which in the federal law is $2 million for the amount of indebtedness that can be forgiven for tax consequences. If it's your principal residence and you occupied the property for the prescribed period of time, the amount of income that's realized is excluded from taxation. So it's not that it's not taxable, but there's an exclusion that allows you to avoid the taxation. California has complied recently with that, for there was a period of time when they didn't comply. It's a lesser amount that's excludable. It's $800,000 that's excludable in California. So you have to look at all these laws and the numbers that apply, but at least to some extent you can avoid the tax consequences of debt relief income on a principal residence.
Yeah. So maybe I'll just fill in a little bit here because there may be some confusion. So some people may think, oh, $2 million, my debt cancellation may be $500,000 on a $2,500,000 loan. I only had $500,000 canceled,
right,
so I'm okay.
No.
No. So it's the amount over the $2 million of mortgage,
right,
that may be subject to tax. And so so you have to look at that. And when you talk about $800,000 for California, well, there's an awful lot of $1 million mortgages in California.
Right.
With our real estate prices, especially here in Santa Clara County and some of the other tonier areas. Right. It doesn't feel so tony. It just feels like the prices are awfully high.
Right. You're also going to have people who have protection under the federal law, but not full protection under the California law, and that gets to be confusing as well because they think they're protected, and then it can turn out to be a considerable amount of California tax that they still would have to pay.
Well, that's right. And so that means you may qualify for an exclusion under federal that you don't for California, and now you have to look at, okay, well, are there any other exclusions that are going to help me out? So what other exclusions apply?
Well, you could, instead of going through these processes, you could file for bankruptcy. Yeah. You have to qualify. If you have a $2 million house, you may have trouble qualifying. But if you did qualify, it's a way of eliminating mortgages, and it's not income because you don't have debt relief. You have cancellation of indebtedness. And so, you have discharge of indebtedness through the bankruptcy court process. So it's something people should investigate if they have these problems, because not only from the standpoint of dealing with the lenders, but from the standpoint of the tax consequences. If you go through something like a modification or a short sale, or even just let your property be foreclosed, and you end up with a tax liability because of that, now you have a debt to the IRS, and then if you file for bankruptcy because of other problems, you have a very difficult time, as I'm sure you could tell people, getting rid of that kind of debt because it's a tax debt.
Right, so it's not usually cancelable, right, unless it's like an old IRS debt or something.
So if you're going to end up there anyway in the long run,